you on mic? Go ahead, sir.
Good evening to all of you. Today we will discuss pleadings as far as injunction matters are concerned. Before going to the practical aspect, I would like to say something about the theory. Here, injunctions are of four types. One is called interim injunction, another is called temporary injunction, another is called perpetual injunction, and another is called mandatory injunction. Strictly speaking, the perpetual injunction and mandatory injunction are covered by section 37 to 39 of the Specific Relief Act. And as far as temporary injunction is concerned or interim injunction is concerned, it is covered by Order 39, Rule 1 and 2, Civil Procedure Code. Before going into the practical aspect, we must know the definition of all this. Here, as far as interim injunction is concerned, it is as a temporary measure which is granted by the court based on facts and documents and when also considering the emergency which is required. Here, as far as suit for injunction is concerned, when it is filed, it is normally filed as suit for perpetual injunction. Please remember, no one files it as suit for temporary injunction. We have seen advocates by mistake writing it as suit for temporary injunction. No suit lies for temporary injunction, please. Please bear that in mind. So, suit for perpetual injunction. Here, perpetual injunction means injunction that is restrained forever, as far as till the disposal of the suit. Interim injunction means where, as a temporary measure based on facts and documents, where the court finds that a prima facie case has been made out, balance of convenience is there, and also hardship will be suffered by the party if urgent orders are not passed, then the court passes what is called ad interim injunction. That means an injunction operative only for a particular duration of time. After the CPC was amended in 1976 by Act 46 of 1976, it has been said that court shall not grant ex parte injunction orders and unless they hear the opposite side and know because of the principle of adi alteram partem, the other side also should be given a fair opportunity of presenting his case, presenting his defense, presenting his documents, and he should be heard before an injunction order is passed. But sometimes what happens is, if the court, based on facts and documents, comes to the conclusion that issuance of notice will frustrate the very purpose of the suit, and on facts, the court has to pass a speaking order why issuance of notice will frustrate the very purpose of the suit and grants ad interim injunction. That means injunction operative for a particular duration of time. But the easiest method open to the court is pass status quo orders, saying that things stand where they are. And then once the injunction order is passed, it is a duty of the plaintiff's advocate to file an application, file an affidavit before the court under Order 39, Rule 3, saying that the copies of the plaint, copies of the petition, copies of the documents have been dispatched to the opposite side by registered post and the postal receipt is filed. And please remember, unless you file this affidavit under Order 39, Rule 3, your injunction will not be communicated to the other side. And one more thing you must remember is that once you take an order for an interim injunction, it is operative only up to a particular date, subject to the other side appearing and filing his counter and filing his defense and also the documents in support of his case. And then if the counter is not filed on the day when the defendant appears, then you will have to file a memo or a petition before the court, ask the court to extend the interim orders till further date till the counter is filed. And till the counter is filed, you must go on filing extension petitions. Unless you file extension petitions, the interim injunction works itself out. Then we come to the second type of injunction called temporary injunction. Temporary injunction is normally granted under the provisions of Order 39, Rule 1 and 2, and normally the suit is filed for perpetual injunction, and along with that, you file an interlocutory application under Order 39, Rule 1 and 2, accompanied by an affidavit, and then state all the reasons and why injunction should be granted. Then when the notice goes to the other side files a counter, and then the matter is heard threadbare on both sides, and the court passes an order. If the court agrees with the plaintiff, the court says the interim injunction already granted is made absolute. That means a temporary injunction is granted, which is operative till the disposal of the suit. Suppose the court is not convinced with your argument or your case facts and documents, the court dismisses your application. That means the interim injunction granted already stands vacated. Then the third type of injunction, which you can visualize, and please remember all orders under orders for temporary injunction is passed under Order 39, Rule 1 and 2 CPC. Then the interim injunction gets converted into temporary injunction once the other side also is heard. Case law is also submitted on facts and circumstances. The court hears the matter and disposes it off accordingly. Then the next one is the next type of injunction is what is called perpetual injunction, or what you call it as permanent injunction. This is normally granted under Section 38 of the Specific Relief Act, which says you must establish prima facie case, balance of convenience, and you will have to say you will suffer great hardship in case the injunction is not granted. Then once the evidences are laid on both sides, and then matter is heard and argued, and written arguments are also filed, court based on the issues framed and the evidence on record proceeds to pass a judgment as far as the vis-a-vis the facts of the case are concerned. And then the temporary injunction, which is granted operative till the disposal of the suit, gets converted into a perpetual injunction. Then we have got one more injunction called mandatory injunction. Mandatory injunction is normally granted under Section 39 of the Specific Relief Act, which says, please remember, a permanent injunction or a temporary injunction promotes inactivity. Where a wrong has been committed, about to be committed, threatened to be committed, apprehended to be committed, then the other side is restrained through a restraint order or a gag order not to proceed further. But mandatory injunction is once, let us say, the authorities or the individual is inactive to your protest, let us say the ingress and egress of to your property has been impaired by the acts of the other side, or let us say a window has been opened which affects your rights of privacy or easementary rights over the property, then in that case you can ask for a mandatory injunction commanding the other side, ordering the other side to undo the wrong which has already been committed. That is, in other words, mandatory injunction promotes activity, but permanent injunction promotes inactivity. So, summarizing the theory part of it, interim injunction and temporary injunction are normally granted under the provisions of the Civil Procedure Code, more particularly Order 39, Rule 1 and 2. Perpetual injunction is normally granted under Section 38 of the Specific Relief Act. It is forever till the disposal of the suit, even after the disposal of the suit. And mandatory injunction is granted if things are not done in the proper perspective, then that can be undone by promoting activity and asking for mandatory injunction. This is the theory part of it as far as injunctions are concerned. I also told you yesterday that injunction is pronounced in has different applications from different professionals. As far as a legal man is concerned, injunction means a restraint order. As far as the surgeon or the physician is concerned, who is in the doctor's profession, it is called injunction. And each has got its own sphere of activity. So now we come to the practical aspect as far as drafting of a plaint in respect of injunction matters are concerned. Name of the court, suit on the original side, that is OS number of whichever year, then name, address, and description of the plaintiff and the defendants, and then you say suit for perpetual injunction under Section 38 of the Specific Relief Act, and all plaints in the civil court are filed under Section 26, read with Order 7, Rule 1 and 2, CPC. Then you say suit for perpetual injunction under Section 38 of the Specific Relief Act, first, second, third, and fourth paragraph. That is name, address, and description of the plaintiff, name, address, and description of the defendant. Again has to be typed. And then you say address for service. You suppose you are the advocate, your address, your cell number, and your email number has to be furnished. Then address for service of the defendant is the same as given above in the cause title. Then after that, fifth is the brief facts of the case, that the plaintiff is the absolute owner and possessor of house number so and so at measuring so and so, situated at so and so, by virtue of having purchased the same through a registered sale deed bearing document number so and so, dated so and so. The certified copy of the sale deed is filed and marked as document number 1. Next para, that the defendant claims that he is the owner and possessor of the adjacent property bearing number so and so, at measuring so and so, so and so, situated at so and so, that the defendant high-handedly on so and so date came to the suit scheduled property and attempted to encroach and occupy the suit scheduled property. The plaintiff resisted the said sinister attempts on the part of the plaintiff, on the part of the defendant, and the defendant went away, stating that he will come with a higher force and disposes the plaintiff. And hence the plaintiff has no other alternative than to file the present suit for perpetual injunction to safeguard his ownership as well as possession. Next para, that the plaintiff submits that he has got a prima facie case, balance of convenience, and will suffer great hardship in case the orders prayed for is not granted. And the plaintiff further submits that he is in actual physical possession of the suit scheduled property and he has got the necessary documents to support his title, and the facts also support his title and possession of the suit scheduled property. Next para. Cause of action for the suit arose on so and so date when the defendant, accompanied by unsocial elements, came to the suit scheduled property and tried to encroach and trespass into the plaintiff's property. The plaintiff resisted the said attempts, but the defendant threatened to come with higher force and occupy the plain scheduled property. Next para. This honorable court has jurisdiction to try this suit as the suit scheduled property is located at Neridimet within the jurisdiction of the Malkajgiri Mandal and the Malkajgiri courts. Next para, the suit is valued for the purpose of court fee and jurisdiction at rupees 30,000, which is the notional value, and a court fee of rupees dash is paid under section 26C of the TGCSV Act 1950, TGCV Act 1956. Next para. The plaintiff further submits that he has a prima facie case, balance of convenience, and great hardship will be suffered in case the injunction order prayed for is not granted. The next para is the plaintiff further submits that he has not filed any suit in respect of the same cause of action in any court of law, nor any suit is pending. Last para is prayer clause. Prayer clause, we have to draft it very, very carefully. The plaintiff therefore prays for a judgment and decree against the defendant or defendants, as the case may be, as follows. For perpetual injunction, restraining the defendants from interfering with the plaintiff's quiet and peaceful possession of house number so and so, at measuring so and so, with plinth area so and so, situated at so and so, through perpetual injunction. B is cost of the suit. Then the party signs. It is also signed by the counsel. Then it is verified, and the place of verification also is mentioned, and the date of verification also is mentioned. Then the party signs. Then whatever documents you file, list of documents filed along with the plaint, 1, 2, 3, 4, 5, 6, whatever it may be, then the party signs. Then one important thing you must remember is, since the suit for injunction refers to immobile property, the schedule of property has to be clearly given. All that piece and parcel of house number so and so, with measuring so and so, with plinth area of so and so, in survey number so and so, situated at so and so, bounded on the north by so and so, south by so and so, east by so and so, west by so and so, and then the party also verifies, saying that the schedule mentioned above is true and correct, and then the party signs. Then you prepare the docket. Then what are the papers you file, sir? You file what is called a interlocutory application, what is called verification affidavit under Order 6, Rule 15, bracket 4, CPC. I think you know what is verification affidavit. All the facts are true and correct. Then you also file what is called Order 6, Rule 14, CPC. Say giving out the addresses of the parties and say the addresses mentioned above is true and correct, and then the party signs as a deponent. Please bear one thing in mind, that if a person is a Hindu takes oath and that's why he's called, or a person who deposes to the facts on oath is called a deponent. And as far as a Muslim is concerned, a Muslim does not take oath. He only affirms to the facts. And that is the reason we say solemnly affirm and state as follows. And beneath it, you say affirmant, sworn, not sworn, affirmed and signed on this the day of so and so before me, advocate. Then you file BATA, or what is called process for service of summons on the other side. That is what is called form number 61 as per the civil rules of practice. And along with that, you also enclose what is called settlement of issues. For each party, it is in triplicate, and then the copy of the plaint, and then you will have to pay process through court and registered post, and also furnish the postal cover and acknowledgement with the proper addresses. Then if you are asking for any interim orders, you also pay the BATA under form 61, and also and along with that you enclose what is called notice to show cause general, and there the summons are served in duplicate, and notice is served in duplicate, and a copy of the petitions also along with the affidavit has to be enclosed. Then you file what is called list of documents under form 51 of the civil rules of practice. The same thing, you fill up whatever documents you file, you just enter it and then file it, and then as many parties are there, you file extra number of copies so that it is served on the other side. And please remember, one thing is that the rules have to be complied with great elasticity, with alertness, skill, and experience. And even any omission on your part will entail in the dismissal of this suit. And then here, one thing you must remember is the stage at which then if you want any urgent orders, I already told you, you must file an interlocutory application under Order 39, Rule 1 and 2, read with Section 151 CPC. And even in the petition, you will have to mention what is called the schedule of property where the injunction orders have to be affected. And then you also furnish extra copies to the opposite side. Please remember, whenever you take an injunction order, you can also apply for file a memo into the court asking for a carbon copy of the order so that it will be useful to you to submit it to the police station. Then one more question which is often asked is whether police protection can be granted for implementing the injunction orders. There are various judgments starting from 1959 Andhra Pradesh of Justice Gopal Rao Egboti was the then Chief Justice, and also later on the comprehensive judgment of Justice Sumalata, who has concised almost the entire law on police protection, and she said under Section 151 it is only the police which can implement the order, and the court can grant police protection by directing the station house officer of the concerned police station to give police protection to the person concerned. Of course, one more question was asked in my previous lecture, sir. The courts are not accepting, that was asked by Mr. Sharma or someone, I don't remember, or Mr. Vittal Rao. So the courts are not accepting the judgment of Justice Sumalata. Please remember, and they are saying, you please file a petition under Order 21, Rule 32 to implement the injunction orders. Here, please remember, Order 21, Rule 32 covers or visualizes a case where the suit is decreed. It applies only to execution matters, not for interim, not for temporary injunction matters. And then there is one more version also which was put forth. Say, please remember, you got a remedy. If the court does not agree with you, file a petition under Order 39, Rule 2A. I ask the court to punish the respondent for disobedience of the injunction orders. So these are all the remedies which are open to you. And please remember, in the suit, you don't state all these things. And all these matters, when you want interim orders from the court or temporary injunction orders from the court, you file an IA, or what is called an interlocutory application. Or to put it in a simple language, it's a miscellaneous application which is filed during the course of the proceedings. In the original suit, it is normally filed in the form of a petition and accompanied by an affidavit swearing to certain facts. Then we go to, then what is the difference between temporary injunction and perpetual injunction, sir? As far as interim injunction is concerned, it is valid or operative only for a particular duration of time. It is not permanent in nature. As far as temporary injunction is concerned, it is passed after hearing both the sides, then it is operative till the disposal of the suit. Then, as far as perpetual injunction is concerned, it is the ultimate or is the finale, where the evidences are laid on both sides, where the case law is cited, where the inconsistencies, admissions, contradictions, everything is pointed out during the course of arguments, and the case law on that subject also is submitted, and the court, based on facts and circumstances and vis-a-vis the evidence that is recorded, passes a judgment, either agreeing with the plaintiff or not agreeing with the plaintiff. If the court agrees with the plaintiff, the suit is decreed and the temporary injunction gets converted into a perpetual injunction. And it is a judgment in rem. It operates as far as the entire world is concerned. Then the question, when we come to mandatory injunction, I said as far as temporary injunction, interim injunction, or perpetual injunction is concerned, it promotes what is called inactivity. Activity has already started. There is a full stop put to that by a prohibitory order or a preventive order that is passed under the interim order or the temporary injunction or the perpetual injunction. But as far as mandatory injunction is concerned, it promotes activity. What do you mean by promoting activity? It means, suppose what the authorities have to do, what your neighbor has to do, he has been negligent as far as his duties are concerned, in spite of several demands and requests, then you can ask the court to pass a positive order directing the other side to undo the mischief what has already been committed. For example, suppose someone constructs on your 25 square yards of land, occupies your property, you cannot just take only a perpetual injunction. You must also take a mandatory injunction saying that to ask the other side to remove the constructions and then demolish the constructions at his cost. And if it is not done, to be done at the cost of the defendant. That is, in other words, I'm putting it this way, sir. A perpetual injunction promotes inactivity, but mandatory injunction promotes activity. I told you also, sir, suppose you have obtained an injunction order and you're even assuming the injunction orders are communicated to the other side, but still, in spite of the injunction order, the other side goes along with the mischief, commences the construction, completes the construction, and you are helpless. In that case, you can amend your plaint and ask for mandatory injunction also, asking the pay the extra court fee, whatever is the extra court fee you have to pay it, and then ask for mandatory injunction also to remove the offending structures. So these are the four types of injunctions that are normally found as far as the law of injunctions are concerned. Next, we pass on. And then one more thing, sir. When I come to appeals, I'll discuss it. Here, then next one is we discuss about suits based on fraud. Suits based on fraud. I think I've discussed it when I was doing that cancellation of decrees, cancellation of instruments. Suppose, let us say, all these other facts you can mention, but the element of fraud is easy to plead fraud, but it's very difficult to prove fraud. Why? Because the acts which have been committed by the other side, where the other side knows that what representation is making is false, but they deliberately makes a statement which he knows to be false, but misleads the other side. The other side, based on trust and confidence, changes his position, which he would not have done but for the mischief played by the defendant. Then in that case, a suit can be filed for cancellation of the instrument on the ground of fraud. Please bear one thing in mind, sir. It's easy to say fraud, but you must mention the ingredients that are required to constitute fraud under Section 18 of the Civil Procedure, Contracts Act. Contracts Act. And you will have to plead and say, sir, this statement was made. The other side knows that he has no title. Other side knows that he has no possession. Other side knows everything. But I believed him completely. I placed trust and confidence in him and changed my position, which I not have done, but for the fraudulent representation made by the other side. Therefore, the question is, I want that particular instrument to be cancelled as per law. And then please remember one thing, under the Limitation Act, there is no limitation whenever fraud has been committed. As far as fraud is concerned, it is not the date when the fraud is committed, but it's a date when the fraud has been discovered. In the cause of action paragraph, we'll have to clearly mention, sir, the fraud was played on so and so date, which came to my knowledge on so and so date when I obtained for a certified copy of the documents and came to know that a calculated fraud has been played on me, and therefore I'm filing the present suit for cancellation. Then please remember, as far as limitation is concerned, when you want to set aside an instrument under section 31 to 33 of the specific relief act, there is a limitation article 58 and 59 of the Limitation Act of 1963, which says 3 years from the date of fraud. But it also says 3 years from the date of discovery of fraud. That is the reason why you will have to clearly say when you came to know about the fraud, when you took the action, how did you come to know about it, what are the documents you have taken, and what is the source of your information that fraud has been played. They have to be clearly pleaded, not only pleaded, but also established. So when fraud has been played, it is an exception to Article 58 and 59 of the Limitation Act 1963. Then you say the prayer part of it, the plaintiff, therefore, the jurisdiction part of it, and all these things. Then the plaintiff, therefore, prays for a judgment and decree against the defendant or defendants, as the case may be, for cancellation of the instrument bearing document number so and so, dated so and so, got into existence through fraud, and then cost of the suit. Then next one is what are the relief or reliefs as the court deems fit or proper. The party signs it, the counsel also signs it, the party verifies the plaint, and also mentions the place of verification and also the date on which it is verified, and the list of documents which you rely in support of your case also you mention in the party signs. And if it is relating to immovable property, schedule of property has to be clearly given along with the boundaries, and also it has to be verified by the party stating that it is true and correct, and the party signs it. And next one is same thing, verification affidavit under Order 6, Rule 15, bracket 4. Then Order 6, Rule 14, stating the giving the addresses and saying that the address mentioned in the plaint are true and correct. And then along with that, suppose you are asking for any interim order, then you file an interlocutory application under Order 39, Rule 1 and 2 CPC, giving the schedule for the property, and you pay the process under Form 61 of the Civil Rules of Practice, which is popularly called BATA. Along with that, you enclose what is called summons for settlement of issues, as many number of parties in triplicate, and also you pay some process through court and registered post, and furnish envelope, post and envelope with acknowledgement, proper addresses duly filled up, and the copy of the plaint which you file into the court, you enclose it. And then if you are asking for any interim order, pay the BATA also for that in Form 61, and also enclose what is called notice to show cause general in duplicate for each party, and then enclose the copies of the petition which you have filed into the court. And then you you also file the list of documents under Form 51 under the Civil Rules of Practice. Fill up the list of documents. I think by this time you know what list of documents mean. And then also furnish extra copy of the documents for service on the other side. And then one more important thing you must remember is under Order 6, Rule 1, that is the amended CPC, you will have to file the plaint in duplicate, and also an extra copy for the purpose of scanning and for computer, and then furnish all the papers and furnish all the documents. And then it is how it, and you also file what is called Form number 8, that is what is called description of the property. You are supposed to fill it up: serial number of the property, survey number, extent, where situated, then rental value of the property, market value of the property, and then under what provision you pay the court fee. You also mention the party signs. And this is how a plaint is filed in respect of injunction suits. I'm sorry, in respect of suits based on cancellation, based on fraud. The same rules apply as far as suits based on mistake, unilateral or bilateral. When the contract is voidable, exercisable at the option, avoidable at the option of the party whose consent is not free, be it unilateral or bilateral, the circumstances which give rise to that mistake, you will have to narrate it particularly you came to know about that mistake. You'll have to show the source of information and supported by documents. So the same thing here also. Suppose, let us say, here also you give the description of the property, the schedule of the property, verify the property, whatever documents you are filing, along with the plate, you will have to clearly mention. And in case you are asking for any interim order, file an interlocutory application and also supported by an affidavit. And the same thing, settlement of issues, notice to show cause general, then list of documents, so on and so forth. So this is as far as mistakes are concerned. Fraud is also concerned. Now we go to, please remember, till now I have discussed about 28 pleadings. 28 plaints I have discussed. I have never discussed this number of pleadings even while lecturing for 28 years, please. But for the benefit of all of you, because you are all responsive and you are also encouraging me to go further and further, that's the reason why I'm discussing so many number of pleadings, please. Then we go to the motor accident claims. Under the Motor Vehicles Act, whatever accident occurs which results in injuries or which results in death, uh, in OP can be filed. MVOP they call it, Motor Vehicles Accident OP, original petition before the Motor Accidents Claims Tribunal, and normally it is a district court or the additional district court as far as the courts are concerned. And then you say name of the petitioner, name of the respondent, and insurance company also you mention, and then you give the brief facts of the case, what happened, that on so and so date, at about so and so time, the plaintiff was proceeding from Sainipuri to Neridimate Crossroads, and and on the way, a lorry with a number so and so, in a rash and negligent manner, came from the opposite side and dashed the two-wheeler driven by the complainer, driven by the petitioner, and with the resulting in multiple injuries to the petitioner, and he was admitted in the hospital and underwent treatment and spent a lot of money as far as hospitalization and surgery is concerned. And the claim, and therefore, and the vehicle which dashed dashed the petitioner was insured with the National Insurance Company Limited with policy number so and so. The policy, the place of the accident report, Panchanama, as well as the recorded by the police are filed and marked as document number 1 and 2. And a copy of the insurance policy furnished to me by the police authorities is also filed and marked as document number 3. And the FIR registered by the police is also filed and marked as document number 4. Then next one is the Panchanama, which was drawn by the police authorities on the spot, spot of accident, is also filed and marked as document number so and so. The next para is the plaintiff further submits that due to the accident, his leg was amputated and then he has become permanently incapable of performing any duties, and therefore he is claiming compensation for the accident as follows: actual amount claimed, then hospitalization, then diet charges, then cost of medicine, so on and so forth. He claims a particular figure. Then he pays. Then the cause of action for the petition arose on so and so date, when the respondent in the high speed dashed against the petitioner and caused multiple injuries, resulting in the amputation of the right leg, and the petitioner being incapacitated for life from performing any duties. Then next paragraph, and also on so and so date, when the petitioner through his legal notice served on the respondent the claimed damages as mentioned above. Then the next para is, this honorable court has jurisdiction to try this issue as the accident occurred in so and so place and resulting in the multiple injuries to the petitioner. And then next one is, no prior petition is filed in respect of the same claim in any court. And then you pay the court fee. Court fee is paid according to a particular slab, sir. It is there in your diary also. Up to a particular figure, there's a court fee. Up to a particular figure, there's a court fee. And up to a particular figure, there's a court fee. You kindly verify from that. And the last one is, the petitioner therefore prays that this honorable court may be pleased to award compensation of rupees so and so to the petitioner for the injuries caused to the petitioner due to the rash and negligent driving of the by the respondent, and then the party signs, it is verified, and whatever documents you file in support of your claim, you mention it in the form of disturbed documents, and then the party signs, so on and so forth. So this is how a motor accident. Please remember, printed form is available as far as motor accident claims are concerned. You need not labor much. Take the printed form, get it typed, and file it according to law. That is sufficient. Then you pay process for service on the other side, and then the forms are available for notice to the respondent under the motor accidents cases, and then furnish extra copies of the claim petition to the insurance company as well as to the respondent. Then whatever documents you file it under Form 51 of the Civil Rules of Practice and furnish extra copies of the petition, extra copies of the documents to the other side. And you are also supposed to file a verification affidavit under Order 6, Rule 15, bracket 4, verifying all the facts mentioned in the claim petition. And then whatever documents you want to file, mention it in the form of list of documents and furnish extra copy to the other side. And that's how matters are filed before the motor accident cases. And please remember, in motor accident cases, one important thing you must remember is even though the respondent may not be guilty, even though the respondent may not have committed the accident, or it may not be negligence, there is one thing called no fault liability. Under the no fault liability, 50,000 is normally granted to the petitioner because the court will have to give something to the petitioner. But please remember, if let us say it results in death, then the dependents who file the OP are entitled to a particular proportion because of, let us say, loss of consortium, loss of company, loss of the person concerned, then the cost incurred in the hospitalization, the diet charges, then the surgery charges, so on and so forth, and the dependency and the last drawn income of the petitioner, you mention it, and file the salary certificate. And please remember, as far as grant of compensation is concerned, the Supreme Court has laid down guidelines saying that expectancy of life, please remember, in India, previously the mortality rate was 35. But because of the improved medicinal facilities, improved technology, the mortality rate in India has increased to 70. Now the expectation of life is 70 years. Above 70, it's only grace. We live on charity, what is called RAC, reservation against cancellation. At any time, you may kick your bucket. So the question is still 70. Normally, it is presumed that a person is hale and healthy. Younger the person, the greater the compensation. And the person and the job position also will be considered, and the multiplier will be applied as the depending on the age. And one more important thing is, when the minors are involved, the court directs the insurance company to deposit the compensation in the court. And once it is deposited in the court invests it in fixed deposit in the name of the minors represented by their guardian. And the guardian cannot walk away with the money. The guardian has to only claim interest in respect to the fixed deposit from time to time. And in case they want to withdraw, the permission of the court is absolutely required. And one more important thing you must remember, the changes which have been brought about by the Supreme Court in accident cases is mostly, of course, I'm not casting any aspersions on the advocates who are appearing on the motor accidents cases. Earlier, what used to happen is checks used to be granted in the name of the advocate. Sometimes what happens is only a scrap is given to the party. And it was, I don't want to mention much about it. And previously what used to happen is a lot of complaints were received by the court saying that they have not received the compensation. And that is the reason why today it is said that any compensation that is granted will have to be deposited in the court. And if a check petition is filed to withdraw some part of it, and the party has to furnish a copy of the Aadhaar card, copy of the identity card, and also the passbook, so that the amount which is awarded as compensation goes directly to the bank account or the party concerned. The advocate has no role to play. But of course, we advocates are very, very clever. What we do is we take a prompter note, please remember, accident cases is a cream as far as the lawyers are concerned, provided it is used properly. But please remember, sometimes be very careful. When you file an accident claim, at least receive 25% of the fees at least, because after the compensation is granted, your party will not see you. Why? Because the money goes directly into the bank account of the party. You have no role to play in that. But each man has got his own technique of recovering his money. So along with that, you file the verification affidavit, Order 6, Rule 14, verifying the addresses, and then the list of documents, so on and so forth. So that is as far as motor accident cases are concerned. Then we go to labor disputes. Labor disputes do not form part and parcel of the law of pleadings in civil law. It's a specialized field under the Industrial Disputes Act. I'll give you a brief resume as to what are the normal claims which are filed, sir. Under the labor law, there are various courts: labor court, industrial tribunal, national industrial tribunal, and then works committee, so on and so forth. But normally the labor court here in Twin Cities are called industrial tribunal. They are also called labor courts. Here, two types of disputes arise. That is a dispute between the workman and the employer. Here, the workman is aggrieved because let us say he has been terminated from his service without any proper grounds. Then what the previous procedure was that you have to go through the conciliation proceedings before the assistant labor commissioner. Both the parties are called and matters are sought to be settled. But normally, the matters are not settled before the conciliation officer because of the adamant attitude adopted by both the parties. Then, in that case, what happens is the conciliation officer tries to settle the matter across the table, and then if he is able to settle it, then he reports to the government, sir, the matter has been decided, matter has been resolved, please pass an award. Only the government can pass an award. But if the conciliation is not successful, then he refers the matter or refers the parties to go to a labor court. And normally, earlier it was you can file a labor dispute or industrial dispute only under Section 2A of the Industrial Disputes Act, which talks about industrial dispute. But later on, because of the labor legislation, they introduced a new section called 2AA. That means even an individual without the intervention of the union can file a representation before the industrial tribunal, listing out whatever grievances he has got. And please remember, it's not necessary that an advocate should appear for him. In the form of a verified petition, he can file it under Section 2AA of the Industrial Disputes Act before the tribunal. And then the matter is heard summarily, formal evidence is led, and then arguments are advanced. And if the court is satisfied that the principles of natural justice have been violated and the employer is not given an opportunity to the workman to represent his case, then the court orders reinstatement of the employee concerned, who is the petitioner. Then it passes what is called not a judgment, please. It is called an award. Earlier, I used to appear for the workmen on behalf of Telugu Desam Trade Union Congress. There we had an advantage. Back wages used to be granted right from the date of the illegal termination till the date of payment. And there an advocate gets his fees, because till such time the case is over, you have to feed the party, because the party will be penniless. And but later on, because there is one section called Section 17 of the Industrial Disputes Act, which says in case the management wants to file a writ petition, please remember, no appeal lies against an award passed by the labor court or the industrial tribunal. Only you can file what is called a writ petition under Article 227 of the Constitution of India. And there, if the writ petition is filed and reinstatement is ordered with back wages, half the back wages has to be deposited by the management. But now a party is satisfied if he gets reinstatement, that is enough. Even if back wages are not granted, he's not bothered about it. But that's it. In the High Court, the matter goes on accordingly. They serve a ID, or what is called ID is industrial dispute, or it's also called individual dispute. And the disputes arise under Section 10 of the Industrial Disputes Act, where it says a dispute between a worker and the employer, and worker and the management. And then it is referred to 4 or 5 authorities called labor court, Industrial Tribunal, Works Committee, National Tribunal for adjudication. Then we go to cases before the Cooperative Tribunal. Please remember, I just take you to section 9 of the Civil Procedure Code, which says all suits of civil nature can be filed in civil courts except those which are expressly barred. Then here normally what happens is the registrar of cooperative societies is entitled to entertain matters arising out of the Cooperative Societies Act, and normally it is in the form of arbitration. And now the private banks also mostly you find private banks and the chit fund companies are also appointing their own arbitrators by requesting the registrar of societies to depute one assistant registrar or deputy registrar to conduct arbitration proceedings. And these arbitration proceedings are conducted by a quasi judicial authority. And here, as far as the Arbitration Act is concerned, three sections are important for us: Section 8, Section 9, Section 11. I'll go one by one. Section 8 deals with what? Suppose there's a clause for arbitration in the agreement between the parties. No civil court can entertain a suit unless you submit yourself to arbitration. In other words, it is called ADR. ADR means alternate disputes resolutions. Alternate disputes resolutions. And when the notice goes to the other side files a memo. Sir, a civil suit is not maintainable. Under Section 8, I'm raising an objection. Matter has to be referred to the arbitrators for the purpose of adjudication. Then please remember the district court where the arbitration proceedings are filed has no jurisdiction to appoint arbitrators. Under Section 11, only the High Court has got the power to appoint arbitrators. The lower courts have no power to appoint arbitrators. Then you got one more section called Section 9. Section 9 speaks about what is called like injunctions, preventive reliefs. That is, suppose let us say some wrong has been committed. You want that wrong to be kept in suspended animation or prevent that wrong to be committed. A prohibitory order that is taken under Section 9 of the Arbitration and Conciliation Act 1996. Of course, you had the earlier act also 1877 or 1897, where you say, suppose you take an award, the agenda has to be submitted to the arbitrators for the purpose of resolution. And the matters that are raised in the agenda has to be answered by the arbitrator. And after hearing both the sides, after the evidences are recorded on both sides and the documents are filed on both sides, the arbitrator proceeds to pass an award. And under the old act of arbitration, you have to, if you want to enforce that award, you must file a petition before the subcourt, ask the court to make it as a rule of law. But by the 1996 amendment, new act was passed, that is Arbitration and Conciliation Act. As soon as you get an award, it is enforceable in a civil court like a money decree. You need not make it as a rule of the court. So this is the history as far as the theory part of it is concerned. Then when you want to file an arbitration proceeding, same thing, sir. You mentioned the award, you mentioned the agreement under clause number so and so. The matter has to be, in case of any differences or disputes between the parties, they have to be referred to the arbitrator, and the arbitrator, the agenda has to be sent to the arbitrator, and according to the agenda submitted to the arbitrator, the matter has to be resolved. And what is the type of dispute which you are having, what are the differences you are having, you spell it out, and then you file what is called, it is called AOP. AOP means Arbitration Original Petition. Of course, much need not be gone into, because we in the lower courts get to get these cases in a very rare manner. Then the last one is the suits before, the claims before the cooperative tribunals. All matters concerning cooperative societies, housing societies, house building societies are covered by the Cooperative Societies Act. And you will have to ask for the proceedings which take place in the cooperative tribunal are like something like arbitration, or elections in respect of cooperative societies, elections in respect of housing societies, in this, elections in respect of welfare societies, the irregularities, so on and so forth, are decided by the cooperative tribunal. Same thing as you draft an OP, the matter is drafted, and the cooperative tribunal disposes of the matter in a summary manner. So this is as far as the pleadings are concerned. We have covered 35 pleadings, sir. I've given you 35 types of suits, how it is drafted. So the law of pleadings, law of drafting, law of conveyancing is over. So what we are left in this particular topic is the professional ethics of advocates. That we will discuss it in the next class. Any doubts? The interaction period starts. Thank you. Yes, Mr. Venkat. Yes, Mr. Venkat.
Sir, good evening, sir.
Good evening.
Sir, MVVF is generally filed under which section, sir?
It is filed on 110 of the MB Act, sir. 110. You have got a separate act called Motor Accidents Claims Act. And that the relevant provision, you file the OP. You file an original petition. And subject to, suppose you lose in the motor accident tribunal, it is subject to a CMA before the High Court, sir. No other court you can go. You have to go to the High Court by filing a CMA.
So, if you do not succeed under the tribunal, can't you go to the district court, sir?
No, sir. The tribunal itself is the district court.
Okay.
So you have to go to the High Court filing an appeal. But
if
now,
we are not filing
no,
sir, if we are not filing before a tribunal, then we can file before.
No, personal. You can't file it before any other court. Only the Motor Accidents Claims Tribunal has got jurisdiction, sir. No other court has got jurisdiction.
That's why the ADJs are.
Sir, actually, it is the principal district court, sir, where it is filed. That man makes it over to the other additional district judges, sir. They are all having concurrent jurisdiction.
Yes. Thank you.
Yes, next up. Mr. Alok. Mr. Alok.
Hello, sir. Good evening.
Good evening, sir.
So, what is the difference between status quo and the ad interim injunction?
Sir, shall I tell you one thing if you don't get embarrassed, sir? As far as injunction is concerned, it is something like a vitamin that is given to you. As far as status quo is concerned, it is neither a victim nor a poison. It is midway. Here, status quo means things stand where they are. You shall not do anything affecting the other side. Other side shall not do anything affecting your rights. You stand where they are. That's the reason it's called the laissez-faire theory. Things stand where they are. They do not move even an inch. That is called status quo. Injunction means you shall not do a particular thing, means you should not do it. That is an order, is in the form of a command, isn't it? So status quo is only for a limited duration of time. Please remember, status quo gives rise to wild interpretations, sir. According to you, one thing is status quo. According to the other side, other thing is a status quo. And status quo is normally violated by the other side. Why? Because they go on with the construction, they go on with the mischief, they undo, they do not respect the order of the court. Of course, you've got disobedience and all, that's a different matter. But status quo gives rise to wild repercussions. Why? Because according to status quo is something, according to the other side, status quo is something else. That's why one of the judges who also rose to be the Chief Justice of the Chennai High Court, Justice Subhashan Reddy, used to say, status quo is nothing but a koja order. He says it is neither a male nor a female. Court should avoid passing status quo orders. Either you grant an injunction or don't grant an injunction. That's it. If you grant status quo injunction, it's something like a bull in a china shop. That's what Justice Subhashan Reddy openly remarked in the High Court, sir. Am I making myself clear to you, sir? Next. Prasad Raghar. Mr. Prasad.
Sir, good evening, sir.
Yes, sir, good evening. Yes.
Sir, you are mentioning about the difference between a Hindu and a Muslim while executing the sworn statement.
Yes, sir. While drafting an affidavit, in Hindu normally takes oath under Gita or Ramayana or whatever it is, or in the name of God. But as far as Muslims are concerned, they are governed by the Shariat. Shariat, the Islamic law, which says a Muslim should not swear. Swearing is against the Islamic law. That is the reason why they affirm, testify, saying that the facts meant. That is why they affirm, means they say that it is true. That is why we mention it as affirm. Don't write it as depose. You don't say as oath. A Muslim does not take oath. Please bear that in mind.
Okay, sir.
It is against the religion.
Okay. Thank you, sir.
Right.
Second thing, regarding arbitration, can you please expand a little bit, sir?
Sir,
What-
arbitration means mediation, sir. To put it in the legal language, it's what is called ADR, alternate disputes resolutions. Instead of going to the court, you want the dispute to be settled through third-party intervention. And arbitrators are persons who are neutral persons, most preferably retired district judges or retired high court judges, who enter into the reference with a fixed agenda and decide the matter and pass an award. That is called arbitration proceedings. He is a non-neutral person who does not belong to either side. He is a neutral person appointed by the High Court, and according to the reference made to the arbitrator, they have to resolve the matter and pass an award. They are something like a quasi-judicial authority, sir. That is an arbitral proceedings rather. And the arbitrator has to go according to the principles of natural justice, give adequate opportunity to both the sides, give adequate opportunity to both the sides to make their case, give adequate opportunity to either side to submit their evidence and submit their documents, and also hear them threadbare, and also go into the case law which has been cited and decide each point of the agenda which is referred to him for decision in a proper way. Something like answering every issue by a civil court, sir. Am I making myself clear to you, sir? And here I would
Yes, sir.
like to make it clear, sir. Lower courts has no power to appoint an arbitrator. It is only the High Court acting under Section 11 can appoint an arbitrator. And under Section 8, once there is a clause for arbitration in the agreement, a civil proceeding cannot go on. But that objection has to be taken at the earliest available opportunity when the respondent appears filing a memo. Then Section 9 is also there. It's called like injunction only. Preventive relief. You can ask for an injunction, but operative only for 3 months period. After that, it dissolves itself. Is it clear to you, please?
Yes, sir. But if either of the parties not satisfied with the decision of the arbitrator,
Then the question is that you have to go to the High Court questioning the award of the. You can file a petition under Section 34 of the Arbitration and Conciliation Act to set aside the award. There is a proceeding section provided for challenging the award. That is Section 34 of the Arbitration Act, sir.
that has to be only in High Court, sir.
Same court. That is a district court, whichever district court it is.
But that will be again a repetition, no, sir, of the entire process.
Pardon, sir?
That will become a repetition, no, sir, again.
Not
The
repetition, sir. On what points there is travesty of justice? How principles of natural justice has been violated? How the arbitrator has acted in a hasty manner? How the arbitrator has acted in a biased manner? How opportunity was not given? Proceedings were not conducted in a transparent manner, and some documents which were filed before the arbitrator was shut out. So there is a travesty of justice, and principles of natural justice has not been followed, or the arbitrator has been influenced by the other side through political pressure or whatever pressure it is there. All these grounds are available to you while filing a petition under Section 34 of the Arbitration Act to set aside the award.
Sir,
And
in
here
your
I would
experience,
like to make a reference here, sir. There is one act called the MSME, that is medium small scale industries. So as far as arbitration proceedings are concerned, the Industries Department appoints a senior officer to act as the arbitrator, accompanied by social worker and revenue official, and then he enters into reference and then passes an award. And against that, there is no appeal provided, sir. Only an original petition is provided under Section 19 of the MSME Act, which says it has to be filed in the principal district court, questioning the award or dismissal or whatever it is, passed by the concerned chairman of the concerned authority. And then under the MSME Act, this is a very harsh provision to say 75% of the award amount has to be deposited when you want to challenge it, sir.
sir, in your experience, as per your wisdom, is it better to go through arbitration or directly file in
Sir,
court, sir?
that's the reason you are an advocate by yourself. Don't incorporate a clause of arbitration. It will be a bull in a china shop. You may agree, the other side may not agree. There is a disagreement always. And you nominate a person, the other side nominates a person, both of you you agree to disagree. I think you have seen the case of the Electricity Commission recently headed by Justice L. Narasimha Reddy. the ex-chief minister submitted his objections saying that I don't want this man to head the commission. He is not competent. Of course, in the High Court did not agree with the previous chief minister, but the matter went up to the Supreme Court. But before it was heard, the chairman resigned and a new chairman was appointed, sir. So, sir, that's why it is said a bull in a china shop. They never include that clause. If you include that clause, you are in trouble, sir.
Okay.
Don't draft it in such a way, including an arbitration clause.
Thank you, sir.
Right. Vasantrao. Mr. Vasantrao. V. Vasantrao.
Sir, good evening, sir.
Good evening.
Sir, landlord has given certain land to on lease to erect a petrol pump.
Right.
But due to some variations in the measurements, he constructed the building adjacent to land that is also building to this landlord.
Yes.
Now the disputes are arose between them.
Right.
Now the landlord want to get back the land.
Ah.
These are constructed on the other land, not in the lease land. That it is registered.
Right.
The boundaries are different.
Right.
Where the pump was erected and what is the actual land was given.
Right.
Then what is the remedy, sir? Now can we cancel the lease deed?
Sir, normally all these lease deeds which are executed, sir, it is executed between the lessee and also the petrol company, whichever it's HPCL, BPCL, or Indian Oil. The question is, they are also parties. Normally, a clause is mentioned. You cannot get rid of a petrol bunk unless you give 6 months notice or even sometimes 1 year's notice also, sir. According to the terms of the lease, you will have to follow and then get rid of him by giving a statutory notice under Section 106 of the Transfer of Property Act.
But this landlord was not entered with the company. Only that the lessee was entered with the company.
Then you'll have to give a statutory notice to the HP company, sir. They're terminating the lease. But you must see the agreement. If you must see the agreement, how many months notice you have to give? Look into the lease deed properly.
Yes, sir. Then the boundaries are different.
No, I'm not for a moment saying boundaries are different, but question is, look into the lease deed. How the petrol company came into possession?
On the lease deed given by the lessee, not lessor.
Lessee means subletting. Subletting. Subletting is not a ground for eviction, sir. Because in the TP Act, unless and until in the lease deed it's mentioned that subletting shall not be done, then only you can get rid of a tenant under the TP Act. But subletting is a ground for eviction in the Rent Control Act, not under the TP Act, sir. Unless under the terms of the lease, suppose, please remember that scenario may not arise, sir, because he has taken it for a petrol bunk, right?
Yes.
Petrol bunk.
That was erected in some other land. Some land it is not within the boundaries given by the landlord.
If it is not within the boundaries given by the landlord, so definitely you can point out the deviations or the inconsistencies and then terminate the lease. Let us see what reply the company gives.
Okay, then we have to give 6 notice earlier.
Notice 6 months, sir. 6 months. Agricultural leases, then manufacturing leases, industrial leases, school leases and all, it's normally 6 months.
You have to mention statutorily 6 months.
6 months, sir.
Okay. Thank you, sir.
Right. Mr. Muralidhar Bala.
Good evening, sir.
Yes, sir. Good evening.
From the partnership firm, memorandum of MOU was written that arbitration clause was there.
Just be a bit loud, Mr. Muralidhar.
In a partnership firm,
Yeah.
am I audible, sir?
Yes, sir. Please go on.
The partnership firm MOU was written, a clause was there for arbitration in case of a dispute.
Right.
Later, by force, he has taken all the partners' check, which was bounced.
Right.
Now, can we object in the court that it has to be, as per the MOU, it should go for an arbitration,
Right.
not a criminal complaint
Right. No, sir. Here,
of its check bouncing?
you can take that plea in the concerned magistrate court under Section 8 of the Arbitration Act, saying that the disputes have to be resolved only by arbitration. and a criminal proceeding doesn't lie. But if you see NI Act cases, they are independent proceedings apart, unlike a civil matter. They are quasi-judicial. So the question is, you can take that plea. Look to what the court will decide. It's a test case. It's a test case. What you are trying to say? There are, to the best of my knowledge, there are no judgments on that.
Okay.
Next, sir. Mr. RRR. Induru Ram Prasad, please. Mr. Ram Prasad.
Yes, am I audible, sir?
Yes, sir. Please go ahead.
Okay. Regarding specific performance, suit filed.
Yeah.
Suit is trial stage.
Yeah.
Agreement of sale. Agreement of sale done.
Right.
Defendant vendor sold to third party.
Right.
And vendor and his henchman interfering with possession.
Right.
Possession also handed over to Wendy.
Yes.
Wendy sublet the property. Some business are taking place.
Right.
Next, defendant and henchmen are interfering and some construction demolition 30%.
Right.
At present,
Are you the purchaser or seller, sir?
Purchase
Purchase. Okay, sir.
30% of the construction demolition.
Right.
At present, what is the reliefs can I ask from civil court, sir?
As far as civil court is concerned, sir, you must enforce that agreement. Is the agreement
Police are not.
Is the agreement registered?
Agreement not registered, sir.
When is the agreement, sir?
21.
21. But every agreement involving immobile property under Section 17B has to be in writing and has to be duly registered. It cannot be looked into for a primary purpose, but under Section 49, it can be looked for a collateral purpose to know the nature of the transaction, not otherwise. But if you are prepared to pay the duty and penalty, you can get the same validated. But please remember, if you want to get it validated, you must go to, or you must ask for, now the sub-registrar is not validating it. They want a direct from the court. Under the relevant provision of CPC, you can file a petition, ask the court to impound it and send it for collection of stamp duty as far as the instrument is concerned. But you cannot avoid the registration part of it because 17(1)B is mandatory.
17(1)B is the mandate.
So you can't file a suit for only injunction, sir. You have to file a suit for specific performance as well as for consequential perpetual injunction.
So in meantime, cannot we ask mandatory injunction, sir?
Mandatory injunction you can ask for what?
Not to interfere with.
It's not mandate injunction. It's a perpetual injunction. Mandate injunction is you must direct the other side to do a particular thing. Perpetual injunction is not to do a particular thing. Inactivity is what is called perpetual. Which promotes activity is mandate injunction.
So first of all, we have to impound 17.
Exactly, sir. Exactly. The document has to be impounded and sent for collection of stamp duty.
Okay, sir. Thank you. Thank you, sir. Thank you.
Mr. SR, please.
Sir, can you explain the Section 34 of to set aside the arbitration award and what is the
sir, as far as Section 34 sir, Section 34 is concerned, sir, you will have to state out what are the terms of reference, what are the issues that are involved, what are the facts of the case, what are the documents that have been filed, what is the evidence that has been recorded, what are the admissions and inconsistencies or contradictions in the evidence part of it, and what are the contradictions in the documents submitted by the respective parties, and also show the biased attitude of the arbitrator, how he has gone at a tangent and principles of natural justice has been violated. Some of the crucial documents have not been admitted, and the question is there is no transparency as far as the award is concerned. The award is biased and award is against the principles of natural justice. These are the grounds on which you can attack the award passed by the arbitrator under the provisions of Section 34 of the Arbitration and Conciliation Act 1996. And please remember, once an award is passed, You need not make it a rule of the court. Like a money decree, all the provisions of Order 21 applies. You can execute it in any manner you like. But when you ask for
What is the time limitation?
no, when you ask for setting aside the award, you must also make the arbitrator also a party to the proceedings. And the time limit is normally 3 months, sir, before which you must challenge the award. And the copy of the award also has to be filed by you.
Can you repeat?
Pardon?
Sir, I'm asking what is the time limitation?
There is time limit is normally 1
Time
month.
limitation, sir. Any
Say once an award is passed, within 1 month you must challenge it, sir. That is what section 34 says. Within 1 month.
thank you.
Right.
Yes.
Vasantrao garu,
Sir,
చెప్పండి.
sir, just now I discussed.
I think your doubt is cleared. Please unmute Mr. Vasantrao.
Good evening, sir.
Yes.
Okay, okay, sir. Good evening, sir.
Good evening.
Once again, sir.
Yes.
Sir,
Yes.
in the at least the lease cannot be terminated within the time of 24 years per se.
Pardon?
The lease should not be terminated within the 24 hours, within the 24 years
Yes.
of the. Then what is the another problem is the rent is not paid regularly.
Yes. What is the rent? What is the rent, sir?
Rent is only that is a nominal rent, only 500 rupees.
500 means you have to go through the rent controller. Rent controller
That
scored
was-
by filing an RC eviction petition.
That was situated in the village area, not in
Even
the,
if it's in the village, is it not the municipal corporation, sir?
not in municipal
Gram Panchayat.
Gram Panchayat.
Then you'll have to go by a civil suit. When there is no corporation there, Rent Control Act does not apply.
Okay, sir. Then I have to go eviction on the ground of not paying the rent.
Ground of default.
Default.
And preferably give a notice so that you may know the defense of the other side.
Okay, okay, sir. Okay, sir. Thank you.
Any more doubts? Can we wind up for the day? All right. Thank you. Prasad Rao garu. Have any doubt?
Yes, please. One last doubt.
Carry
Please
on,
go
carry
ahead.
on, sir.
Sir, I have been given to understand, or by word of saying, that arbitration is better. It works very well in USA.
Not,
but in
not,
India,
not in India, sir. I'm sorry.
can you shed some light on that?
See, as far
Yes.
as in USA is concerned, we have some sense of discipline, sense of responsibility, sense of belonging, and also to see that the disputes don't go to the court. It is decided or settled across the table. But in India, various scenarios occur, sir. It's normally arbitration proceedings end in a fiasco, or I should say, arbitration proceedings are a farce. Because if you see the arbitration proceedings before the chit fund companies or the private banks, please remember the defendant is cornered all the way. Because I still remember I appeared against the Vasivi Cooperative Urban Bank. The registrar says, the person who is the arbitrator says, are you filing the counter or shall I allow the... You are not given even breathing time. They don't have the legal knowledge. They don't have the legal acumen. They don't have the relevant knowledge as far as the Evidence Act is concerned. If it's a judge who is appointed as arbitrator, perhaps it may be good because they know the law, they know the procedure, they know the technicalities which are involved. But normally, registrar of societies who deputes a deputy registrar has no legal knowledge, sir. To be frank, the arbitration proceedings ends in a farce. And please remember, arbitration proceedings, the award is passed, but the arbitrator has no power of execution. You will have to come to the civil court by filing an execution petition to enforce the award, sir.
Okay, if the defaulter is
Somehow I am
found to be-
against arbitration, sir, because the question is no arbitration has succeeded, sir, because the question is whenever you have a clause for arbitration, we agree to disagree. Even if you name an arbitrator, the other side will not name an arbitrator. Or if they're very difficult to have a consensus, sir, unless both the people meet and by consensus, arbitrator is appointed, not otherwise. And normally, as you say, suppose arbitrator on one side, another arbitrator on another side, a referee is also appointed who is a neutral person. And in case of differences between these two arbitrators, the award passed by the referee is final.
Okay. Thank you so much.
Welcome, sir.
Anuradha, please go ahead with your question. Ready me?
Yeah, thank you.
Yes.
Sir, good evening, sir.
Good evening, madam.
Sir, and one more disadvantage of arbitration is the award granted is final, I think.
Yeah.
It is not appealable.
No, it's not appealable, but section 34 says it can be questioned by getting the award set aside.
Okay. Okay.
Yeah.
Okay, sir. Thank you.
Welcome.
All right. Thank you, everyone. We'll see you tomorrow again. Thanks for the participation.
Yeah.